How do you plead to that? True or not true?
Partially true. I did not intend to.
Well, here's the thing. It's either true or it's not true. Court could find it true, motion, find you guilty, sentence you up to 20 years in prison and up to $10,000 fine.
No, ma'am, I did not.
Oh.
Yes, ma'am.
Are you waiving your right to appeal?
I don't know how to answer that question.
The agreement that they've reached, I don't have to accept it. I can sentence you to 20 years in prison.
Yes, ma'am.
So here we are, another day, another defendant swinging between I didn't mean to and I need another chance. This time it's a woman who was charged with aggravated assault with a deadly weapon, and somehow we're still pretending she's just misunderstood. The hearing starts off like every redemption arc we've seen before. Soft voices, sad expressions, and the same mental health struggles excuse to dodge accountability. Don't get me wrong, mental health is serious, but pulling that card every time you swing a weapon at someone, that's not therapy, that's danger. The prosecutor's playing chess while the defense is out here playing feel sorry for me. It's wild how quick the system can turn from enforcing the law to babysitting someone who's proven they can't follow it. So what's it gonna take? Another victim or another excuse? Let's go ahead and dive in.
7574, State of Texas versus Summer Bailey. Did you understand what you're charged with is aggravated assault with a deadly weapon? The range of punishment for that offense is anywhere from 2 to 20 years in prison and up to $10,000. Did you understand?
Yes, ma'am, I understood.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court would find you guilty, sentence you up to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
Showing you what's entitled plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, there's a $1,000 fine probated, affirmative finding of deadly weapon. State recommends deferred adjudication. Taking consideration 661860. There's to be restitution of $150 to Richard Cantu, and there's to be no contact with Richard. Did you understand that to be the plea bargain agreement?
Yes, ma'am, I do.
Thank you. Next, I'm showing you outside the plea bargain agreement. The state is requesting that your deferred adjudication be for a term of 3 years. There'll be a TAP evaluation, 100 hours community service restitution, and a MIC-MILF evaluation. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am, I do.
Then to the offense is charged in the indictment. How do you plead? Guilty, not guilty, or no contest?
No contest, ma'am.
Are you proceeding with sentencing?
Yes, ma'am.
Anything you wish to say on behalf of your client?
Ms. Bailey has no criminal history at all. She does have diagnosed mental health issues, and I believe mental affective disorder and PTSD. And this was an isolated incident, and she certainly meant no harm to this individual. And I think it's kind of clear even from the facts that she was just experiencing an episode. And we just asked the court to follow the plea bargain, and I know she can do it.
Yes, sir.
All right, Miss Bailey, where would you be living if you were released today?
I live at an apartment, and my roommate just ended the lease, and October is the last month there, and then she got a house on the east side, but I'm not sure the new address. The current address is 111 West Travis Street.
Okay, let me ask you this. Have you ever been under the care of a doctor?
Yes, ma'am. I have a mental illness. I take medication.
Have you ever been employed or are you receiving SSI?
I receive SSI now. I have been employed before in the past, and I am currently on disability.
And what is that disability for?
Mental health.
All right, this is what the court is going to do. The court is going to sentence you to a $1,000 fine. That will be probated. There's an affirmative finding of deadly weapon. Taking consideration 661860. Restitution of $150 to Richard Cantu. No contact with Richard Cantu. You're going to have a referral to Center for Healthcare Services. 100 hours of community service restitution. If you obtain the COVID vaccine, the court will deduct 40 of those hours. Again, for the record, I'm not forcing anyone to get the vaccine, but if you get the vaccine or already have the vaccine and provide proof, I'll deduct 40 hours of your community service restitution. Proof of SSI within 40 days of release. Are you able to report by Zoom, Ms. Bailey?
I can figure it out once I get my phone.
Right, so it's going to be regular Zoom reporting or in person. So if something happens and you can't report by Zoom, you'll need to report in person.
Yes, ma'am.
I'm going to want field visits.
Why are we even handing out deferred adjudication for this kind of behavior? This isn't a parking ticket, this is aggravated assault with a deadly weapon. The state's acting like she just made a bad decision at brunch, mental health issue or not. If you're out here endangering people, you don't just get to walk free and try again like it's a class project you failed. That's not compassion, that's negligence. If someone's really struggling that much, fine. Then get them to an actual mental health facility where they can't hurt anyone. But letting them roam around with a we'll check back later plan? Come on. Every slip up becomes part of the healing process, and meanwhile, the next incident could be way worse. We keep confusing treatment with tolerance, and it's costing public safety. What's crazy is if this were a repeat offender with a drug charge, the book would have been thrown already. But here, it's let's give her one more chance. This isn't growth, it's denial with paperwork. And it's setting up the next victim before the ink on this deal even dries.
2 times per month. Sorry, Rebecca, could we also do a MIC evaluation, but that can be done while she's out of custody? All right, we can go off the record. Ms. Bailey, it's very important that you make all of your appointments with probation. If you don't, I'm going to receive a report that you haven't made those appointments, and then there's going to be an issue because a motion to revoke is going to be filed, all right? Versus Summer Bailey. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Angela Blake.
You, Summer Bailey?
Yes, ma'am, I am.
Going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Summer D. Bailey who was placed on deferred adjudication in 2021 CR 7574 for the offense of aggravated assault with a deadly weapon on September 10th, 2021 for a term of 3 years? Is that you?
Yes, ma'am.
State?
Yes, Your Honor. Violating condition number 1, on or about the 5th day of November 2003 in Bexar County, Texas, the defendant Summer D. Bailey committed the offense of burgling the building and attempted theft in violation of condition number 1.
How do you plead to that? True or not true?
Partially true. I did not intend to.
Well, here's the thing. It's either true or it's not true. We can't do partially. So is it true or not true?
Sure.
All right. State,
I'll waive violation of
any
condition.
objections to the state's waivers?
No
Do
objection.
you understand by pleading true to violation of condition number 1, the court could find it true, motion, find you guilty, sentence you up to 20 years in prison and up to $10,000 fine?
No, ma'am, I did not.
You don't know that's the range of punishment for what you're on probation for?
Yes, ma'am, I knew that's what I was on.
All right, so you want to sit and talk with her? And 2021 CR 7574. Ms. Bailey, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
All right. So you do understand that if you have worked out a proposed agreement between your attorney and the state, the court does not have to follow that agreement. Do you understand?
Yes, ma'am.
All right. Is there a proposed agreement?
There is, Your Honor, and it is to continue the individual on her deferred, order her to go to safety with a 8-month extension to her deferred. State will take in consideration in lieu of a plea of true to number 1, which is Night Mag 737-286, which is burglary of a building. State is also asking an additional condition of no contact order with Bethany First Baptist Church at 202 Noblewood Drive here in San Antonio, Texas.
Are you asking the court to follow that agreement?
Yes, sir.
Are you asking me to follow that agreement?
Yes, ma'am, please.
Are you waiving your right to appeal?
Yes, ma'am.
All right, this is what the court will do. The court will deny the motion. Alternate amend conditions to include safety. Does she need a new TAP evaluation for that or no? All right, this is what the court will do. Court will deny the motion, alternate amend conditions to include an updated TAP evaluation. If the TAP evaluation recommends inpatient treatment, then it's to be safety. There's to be no contact with Bethany First Baptist Church at 202 Noblewood, and you're extended for 2 years. All right, is there anything else from either side?
Nothing from the state, Your Honor.
No, Your Honor.
All right, we can go off the record, Ms. Bailey. From here on out, everything you do, you need to ask yourself, did this result in me potentially going to prison for 20 years? When you're on probation, you're not on probation with your attorney. You're not on probation with the state. You're on probation with the court. You understand?
Yes, ma'am.
All right, good luck to you.
Who's surprised she's back in court? Because I'm definitely not. This is the same tired story on repeat. Probation, excuses, repeat offense. Deferred adjudication does not work for people who clearly don't take it seriously. And these judges handing out second, third, and fourth chances? That's not being merciful. They're just postponing the inevitable. Either she's acting clueless, hoping for another sweet deal, or she's genuinely out of touch with what she's done. And both are terrifying options. The whole "I didn't understand the terms" defense is laughable when the terms are literally just don't commit another crime. You don't need a law degree for that. The justice system needs to stop treating accountability like a rare privilege. We need harsher sentences that make people think twice before they end up back here again. I'm not saying throw away the key, but at some point you've got to admit, the system's patience is turning into public risk. It's ridiculous, and honestly, it's insulting to the victims who don't get a second chance.
7-4, State versus Summer Bailey. Can I have parties announced for the record?
Megan Galloway for the state. Like Attorney Miss Bailey.
And are you Miss Bailey?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
I don't understand it, but yes, I have it in my hand.
All right. So basically what that is, that's a document.
Yes, ma'am.
And that document is complaining, and I'm going to tell you in layman's term, it's complaining that you are on probation, that you're currently on probation. Do you realize you're on probation?
Yes, ma'am.
And they're saying that the conditions or instructions that the court has given you,
Yes, ma'am.
they're saying that either you didn't follow it or you violated it in
Yes,
some
ma'am.
way. So do you understand?
Yes, ma'am.
All right. Are you the same Summer Bailey who was placed on deferred adjudication in 2021 CR 7574 for the offense of aggravated assault with a deadly weapon on September 10th, 2021 for a period of 3 years and extended for a period of 2 years? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 43 on or about the 12th day of June 2025 in Bexar County, Texas. Defendant Summer D. Bailey did then and there fail to comply with the rules, regulations, or instructions of the Bexar County Community Supervision and Corrections Department Substance Abuse Felony Punishment Facility Continuum of Care Treatment Plan, and that the defendant failed to attend outpatient treatment in violation of condition number 43.
How do you plead to that? True or not true?
True. I did not complete it.
All right. Did you understand by pleading true to violation of condition number 43? Court could find it true, grant the motion, sentence you to 20 years in prison and up to a
Yes, ma'am.
$10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation 43?
Yes, ma'am.
Court will find violation of condition 43 true. Is there a proposed agreement?
There is, Your Honor, and just for the record, we do waive and abandon the other, or the remainders violations.
Oh, I'm
and-
so sorry. I don't have that report, but
Sorry.
No,
There's-
no.
There's a supplemental that.
thank you for waiving those.
And the agreement for the court's consideration is that you grant the state's motion, revoke the defendant, sentence her to 4 years TDC, and the state is going to take into consideration clause number 2025 PF 35078.
All right. Are you asking the court to follow that agreement, Miss Bailey?
Yes, ma'am.
All right. Would you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. State your name for the record.
Summer Denise
All
Bailey.
right. Are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
I don't know how to answer that question.
All right, so.
I mean, I know what it means. I
Do
just
you
don't-
understand the question?
I understand the question. I just don't know how to answer properly.
You want to speak with your attorney about that?
Really. I guess I'll waive it.
No. I don't want guessing because
I know.
this is very
I know
serious.
it is. I know
So,
it's very
here's the
serious,
thing.
but nobody
Do
will.
you- When you are on probation in a court, the state and the defense, they're really not allowed to have an agreement and then I have to accept their agreement. The agreement that they've reached, I don't have to accept it. I can sentence you to 20 years in prison.
Yes, ma'am.
Now you're telling me you want me to follow the agreement that you've had with your attorney and with the state. Is that correct?
And I said, yes, ma'am.
All right. So if you want me to follow that agreement, then my next question to you is, are you going to waive your right to appeal? You may want to discuss that with your defense attorney.
Yes, ma'am.
All right. So are you waiving your right
Yes,
to
ma'am.
appeal? All right. The court then is going to follow your agreement. The court is going to grant your motion. I'm sorry, grant the state's motion, find you guilty, revoke, sentence you to 4 years in the prison, give you credit for any time served. The court will request the therapeutic community. There's an affirmative finding of a deadly weapon. There's to be no contact with Richard
And
Cantu. Take in consideration 2025 PF 35078. Is there anything else from either side with regards to sentencing?
Judge, just really briefly, it looks like she did complete safety and custody. And I believe she has 273 days credit for that.
All right, so I'll give credit for any time served for a successful completion of inpatient treatment. All right, we can go off the record. So I have requested the therapeutic community for you. It doesn't increase the time that you're in custody. It's to help you with maybe if you have mental health issues, if you have drug issues, it will help you with that. When you're released from prison, if you can't find a place that can help you with that, if I'm still here, you come back here and I'll pick up the phone and call somebody.
Back in court once again, and back playing dumb like it's a tactic she learned from the last round. Finally, the state decides to revoke it, but wow, it only took 3 court appearances and a mountain of patience. She was facing 20 years, and somehow walks out with 4? If that's not leniency, I don't know what is. This case is just a masterclass in how soft the system can get when sympathy outweighs sense. The judge had the perfect setup to send a message, but instead we got another reminder that consequences have expiration dates. Deferred adjudication sounds nice on paper, but in cases like this, it just delays accountability until the next crime. Too many chances, too little correction. So what do you guys think? Does mercy in cases like this save people, or just teach them they'll always get another pass? Let me know your guys' take down in the comments. Thank you so much for watching. Don't forget to like and subscribe, and I'll catch you in the next one.